Okay, we are live, everybody. Hello, my name is Wendy Fournier with the National Autism Association, and I want to welcome you to tonight's webinar with our special guest, Michael Beloff, who is a very old, old friend of NAA. What year was the conference, the first one that you did with us?
I want to say 2007,
Yeah, I think it
somewhere
was,
around there, 2007
yeah,
or
either
2008.
2006 or 2007. So it's
Yeah.
been a while, and a lot has changed.
Yes.
Well, we have changed. Our kids have grown up. They're adults now. And I'm so glad that you're here tonight to talk with everybody about the challenges. Let me look at my camera so everybody doesn't think I'm ignoring you. I'm looking at Michael on my screen. But the challenges that we all face as parents when our kids are getting older and we're wondering what is going to happen to our children when we're not here anymore, and how are we going to ensure that they have a happy and healthy and fulfilling life after we're gone. So financial planning comes into play. This is why we have Michael with us tonight, and we're going to ask you guys in a poll later on what topics you want to dive a little deeper on, because this is such an important and yet really difficult issue to think about. A lot of us get so overwhelmed by it. I know I did, that I just pushed it off for years because I just couldn't even wrap my head around it. It's too much. It's the stuff that keeps you up at night. It's the nightmares. So Michael is a founding partner and wealth advisor at Belvedere Wealth Partners. He's in Stamford, Connecticut, and he has a son. Son's name is Ben, correct?
That's correct.
His son Ben has autism. And Michael has become a chartered special needs consultant with extensive training and continuing education on the complex topics and particular challenges of caring for a dependent with special needs. Michael's expertise and ability to educate and empower has made him a noted speaker on the topic of special needs planning on both a national and local level, including with the National Autism Association. Lots of major organizations are going to this guy because he is the one that you want to hear from. So rather than me going on and on and on, Michael, welcome to NAA's webinar. Thank you so much for being here with us tonight. Please help us understand the process of financial planning for our kids.
Thank you, Wendy. And it's great to be working with the organization again. And I think it's really hard. Wendy's and my kids are both of similar ages. My son is 28. We went through early intervention, the IEP process through the school district, transition programs post 18, and then, of course, the transition to adult services at 22, which is the age in most states. And the process is challenging. And we've spent, usually when kids are aging out, we spent almost 22 years fighting for our kids and struggling against the school district. And then, of course, when we hit adult services, the whole world changes. And I think it can be very, very challenging for families to focus on the long-term planning. We're very good at short-term planning,
Mm-hmm.
which deals with what's going to happen tomorrow, what are the doctors we're seeing, who are the teachers we're talking with, what are the programs our kids are going to be involved with. But I think it's harder to focus on the long-term planning. And so this is a workshop that I do on a regular basis for families. And so, Wendy, should I start the sharing of the slides?
Yeah, go right ahead. I just want to let everybody in the chat know that we'd love to know where you're tuning in from tonight. If you want to post that in the comments on Facebook and also on Zoom. And also, if you are with us on Zoom and you have questions for Michael, rather than using the chat panel, please use the Q&A box for questions. You're welcome to use chat to speak to each other or make comments. But direct questions for Michael later, please put those in Q&A. And Michael, I'm going to turn this all over to you. Let the
Great.
show begin.
And this is really set up to be a primer for families. This is meant to be a top level view of the different issues that as families we're facing when you have a child with autism and special needs. I can and have done an hour on some of the individual topics that are built into here, but this is meant to really be an introduction to go through the basic topics, the basic things that families should be thinking about when doing long-term planning for our kids. And so I do, because I am in financial services. I am in a highly regulated industry. There are some disclaimers that I have to show for about 15 or 20 seconds. I do work for a financial services firm. We will be talking about a variety of legal and tax issues. We have folks here from around the country, and how things work in your state may be a little bit different from the way we're going to be talking about it tonight. So it's important to make sure that for your particular situation and your particular state, especially, that you speak with advisors who understand the issues there and talk with your legal and tax advisors as you do your own individual planning. So in beginning planning, I think it's important to vocalize and memorialize. That means it's important to talk with other family members, with grandparents, with siblings, with your other children, about what your plans and goals are. And then it's going to be important to memorialize that by putting that down in writing. Some of that may be in legal documents, some of that may be in non-legal documents that are just instructions on what your goals and plans are for your child, what your child's plans and goals are for themselves, to the extent that they can communicate that. It will be important to involve the whole family, because there can be accidental things that can happen that can mess up your plan. It'll also be important to coordinate with professionals. For those of you who have kids who are still in school, or for those of you who had kids who were in school, we always had a team around us. There was the special ed coordinator, an OT, a PT, a speech therapist, a special ed teacher. And there was always a large service model around our kids. Sometimes that gets a little bit lost as our kids age out and become adults. And as families, we become a little bit more isolated. But it will be important to have coordination among primary care physicians, the financial planner, the estate planner, and of course, the service coordinator if you're receiving Medicaid waiver supports in your state. And make sure that everyone is on board and working towards the same goals. We're going to coordinate and kind of organize this talk around a non-legal document called a letter of intent, which is a planning tool. You don't need an attorney for this, but it's a planning tool for families with children with disabilities to help them put down in paper a lot of the different things that we're going to be talking about that you want to have as part of your plan for your child, and again, their plan for themselves as well. So when we think about long-term planning, I kind of think about four main questions when I've spoken with parents here locally in Connecticut, where I live, and around the country when I've been at workshops. The four main challenges that I see for families that keep people up at night. Who will watch over my child? Where and how will my child live? How will my child pay for things? And how can I effectively communicate my wishes for my child and their wishes for themselves for future caregivers? And we're going to address each of these four questions. So start with, who will watch over my child? Now, as a reminder, from a legal standpoint, when your child is under 18, disabled or not, you are their legal guardian, and you have certain financial responsibilities for their behalf, and you have certain legal responsibilities on their behalf. Once your child turns 18, they become a legal adult. And unless there's some intervention, they are deemed to be able to make their own decisions about their own lives, their own medical decisions, their own financial decisions, their own legal decisions, their own educational decisions. So as your child approaches 18, it will be important to discuss with your child and also think about for yourselves, what can my child do for themselves? Are they capable of making their own personal decisions, which would include medical, welfare, and residential decisions, either by themselves, with supports, or can they not make them at all? And then probably the second most important are financial decisions. Can they make their own financial decisions with or without supports? And then each family will have to make a choice as to how to manage that decision making. For many families, and this is the more traditional model, they have gone with third party decision making, which is essentially taking away the rights for an individual to make their own decisions about their own life choices. And that's typically referred to as guardianship or conservatorship. I will say, as a personal decision, my son, who has what would now be categorized as level 2 autism, he has language, he has a lot of good ADLs and IADLs, but he'll never pay a bill. He'll never be able to call a doctor and renew his medication, although with autism, he's very good at taking his medication. And so for us, we felt it appropriate to become his legal guardian as an adult. That is typically a legal process. And for those of you whose children are in their late teens and approaching 18, because they automatically become an adult with certain privacy rights at 18, if this is something that you are considering, you should probably start that process about 6 months before your child turns 18. Note that the process is going to be different in every single state in the country, because guardianship and or conservatorship, depending on how it's structured in your state, is covered by local probate courts. In some states, you don't need an attorney. That's true in my home state of Connecticut. In many states, you may need to hire an attorney to go through the guardianship or conservatorship process. Typically, there are two types of guardianship. And again, these are more legal-oriented terms, but there's guardianship of the person, which allows you to make personal decisions on behalf of an individual who's not capable of making those decisions. And then there's guardianship of the estate, which allows you to make financial decisions on behalf of an individual. And often, in most states, you can become plenary guardian, which covers both of those powers. Now, these terms may be slightly different in your state, and you should research this as you go through this process. But essentially, it's taking the rights to make certain decisions on behalf of the individual and placing that in someone else. Often, that is a parent, but it can also be a family member, or it can also be a professional, a doctor, an agency, an attorney, depending on how the rules work in your particular state. Many states also allow for a successor guardian. In my home state of Connecticut, where I am the legal guardian for my child, my brother and sister-in-law are successor guardians. Now, they've agreed to do this. You shouldn't just spring this on another family member. But this is part of the discussions with family to have, that if your child needs a legal guardian or conservator, that you want to line people up. People can't be forced to be guardians and conservators. Typically, even if they're named as a successor guardian or conservator at the death of the original guardians, that person has to step up and go to the local probate court and agree to the oversight of their guardianship or conservatorship. Now, this is a little different from, I think, when I tweeted this last, Wendy, at one of the conferences. We're now seeing a growth in something called supported decision-making, because there are many individuals with disabilities, if they don't have a cognitive disability, or perhaps they have level 1 autism, where those individuals are capable of making their own decisions with supports. And so that this concept of supported decision making has grown over the last few years. On a simple scale, this can be done with what's something called a power of attorney, which is a legal document allowing someone else, not to take away of the rights of the individual to make their own decisions, but to share that right. And so often we see a financial power of attorney, which allows that other person access to bank accounts or other financial accounts. There are educational powers of attorney that allows the parents to continue to participate in IEPs. You may not know this, but when your child turns 18, if you're not their legal guardian, the school can't talk to you. But by having your child sign an educational power of attorney, the school is now allowed to talk to you from a legal basis. Probably the most important of these shared powers are the medical powers of attorney and HIPAA authorizations, which allow doctors to talk to parents about medical care and allow parents to authorize medical care for someone who is not under guardianship or conservatorship if that person is not capable of making their own decision. And often you see this combined with a HIPAA authorization, giving a parent or a third party access to medical records. And again, this end, the shared decision making, does not take away the rights of the individual to make their own decision. It only allows a third party to help them. And if there are issues with understanding, it helps to maybe sometimes translate what needs to be done. Now, some states have gone further than the traditional power of attorney and actually passed supported decision-making laws. And you can see those states at www.supporteddecisionmaking.org, where not only do you have access to sharing kind of these limited financial, education, and healthcare powers, but perhaps other types of decisions. Maybe the family member wants one person to talk to regular doctors and a different family member to be able to talk with certain specialists, or allowing that person to talk to your state Medicaid agency. Sometimes we do see state agencies and organizations not wanting to honor a regular power of attorney. But if you're in a state that has a supported decision-making law, like New York, you can have a larger document specifying who can do what in terms of what the person can talk about. This is a challenging decision. Technically, you can go back and forth as and if your child progresses and is more and more able to make their own decisions if you started with guardianship and conservatorship, or if there's regression, sometimes you can go back to court and create guardianship or conservatorship for someone who had not been through that. I would recommend that if your child is getting close to 18 and you feel that guardianship or conservatorship is appropriate, but you haven't gotten your act together to be able to put that in place prior to them turning 18, have your child sign a durable power of attorney that will allow you to at least talk to the doctors on their behalf without them being present. So moving on from who will watch over my child, probably the thorniest issue these days as the autism wave is getting older is where and how will my child live? You want to think about what is important to you for your child. To the extent that your child can express it, what is important to them? Housing is challenging because it is so much more expensive than traditional day supports for adults with disabilities. Whereas, say, a typical day program in my state of Connecticut for an adult with disabilities might be anywhere between, say, $20,000 and $60,000 to the state. Residential supports are much more expensive. For a traditional group home that, say, might have 3 adults living in a house with 1-on-3 staffing supports and 24/7 staffing there, the price here in the Northeast runs about $150,000 a year per person in that house. And if the child needs enhanced supports, the cost can go up from there. So in most states, there are wait lists to get into housing because of the costs. But you want to think about what's going to be the best environment for your child and what do they want. By default, many individuals are living with family members. Based on research that I've seen, that number right now is about 70% of individual with disabilities are living with a family member. Now, technically, an adult with autism can own their own home. It may not be the best idea. We'll talk about that when we talk about Medicaid in a moment. But they can own their own home, but that may not be the best financial choice. And many families, when there's autism and the individual cannot adequately care for themselves, there's going to be some kind of supported housing. I'm going to touch briefly on different models of housing that is out there for adults with disabilities. The first is the traditional group home that I described earlier, where there's 3, 4, 5, 6 individuals, depending on your state and how they're structured. In a group home, the individuals with disabilities live in the house, and the state provides the staffing for that home, often on a 24/7 basis. And in a traditional group home, there is probably state oversight through a state Department of Developmental Services or something very similar. That type of housing is very, very expensive, as I mentioned, and typically there are wait lists. One thing to consider is that the wait list isn't often a wait list for a slot, it's a wait list for funding. In most states for traditional group residences, there's a wait list on an emergency basis. And so typically it's not if you're 300th on the wait list, you get it after the first 299 people get a slot. Typically it's on a sliding scale where if the parents pass away, that's the harshest emergency. And those people may get priority for funding. But I encourage families often in these types of talks to get in contact with local service agencies that provide traditional group homes to understand how the system works in your state and how perhaps to get on a wait list so that perhaps your child can get into the home prior to the parents passing away. Other models, and many of these depend on your state and how your Medicaid waivers are set up. Most states have some form of adult foster care where an adult with disabilities lives with another family, often after the parents have passed away. And often there are stipends for that foster care family, just like foster care for a child. And that can be an appropriate environment for some individuals. There are home shares. Again, these are going kind of usually from highest need to lowest need. Typically, the higher need individuals will have a traditional group home environment, whereas adult foster care is someone who may be a little bit more independent, but needs a family there. Then there is a home share. I've seen environments where an individual with disabilities needs natural supports. And so sometimes they can be set up in a 2-bedroom apartment with a live-in aid that may either be private pay or they're getting free room in exchange for natural supports for an individual who's a little bit more independent. Sometimes that can be combined with a Section 8 housing voucher, which is federal housing supports on a rental basis. Then there is supported living, where an individual, might be in a grouped environment, say in a building or in a residential situation where the family, often this is on a private pay basis, where families are buying a home in a community with supports being provided because of congregating lots of individuals with disabilities in one place can run afoul of Medicaid rules. This is often um, on a private pay basis, but there are a lot of communities springing up around the country to help fill that kind of need. And then finally, there's independent living, where the individual with autism is able to live on their own with maybe someone coming in a couple of hours a week to help with independent living skills, like bill pay or making sure the house is clean and things like that. What type of environment for your child is going to be dependent on how their autism and other conditions impact them and what the level of supports are. But if as parents, we can think about what would be the right environment to provide safety while having them be independent, that can help shape what you look for as a family. I've always found it interesting that many families fight for inclusion at a school level. We fight for that free and appropriate education in the least restrictive environment. But when we think about housing, our default is a group home, which is probably the most restrictive environment. So I think this is the time to start thinking about what's the environment that your child would thrive in if they were not living in your home. And just know that the style that you pick does not have to be the end style. Again, in the movement towards more independence and more integration, states are looking for what's the level of support the individual needs and moving some individuals who are capable of living more independently out of traditional group homes. Yes, there's a cost savings, and that is some part of the reason behind it. But the other part is that many individuals thrive where they're in the least restrictive environment for their living. Moving on, we're now going to talk about, well, how do we pay for this? And we're going to talk about family resources, government resources, and managing them and perhaps combining them together in a way that makes sense for families. So often there are family resources, and these are important because, especially for those of you who have kids in the adult system, even when you have state funding, the state does not pay for everything. Generally, when you have state funding, it's going to pay for the roof over your kid's head, food, and the staffing supports that they need. It's not going to pay for the niceties of life, the things that you're currently paying for that your kids like. New clothing. My son needs an iPad. Every 3 or 4 years, we have to replace that iPad. We've got to replace the computer. My son is really into license plates. So he's the subscriber to I think it's the Association of License Plate Collectors. And he gets this wonderful magazine that he loves every 2 months from this organization because he is a member, and that costs $80 a year. None of that is provided by the state funding. So you want to look at the family resources that you're putting in place that will be used not only for your retirement and supporting your child while you're alive, but perhaps supplementing what the state is paying for after you've passed away. Those include life insurance, and that's a tactic that many families use, but it can also include your regular savings, allowing for a portion of your retirement savings once you're gone. There are some tax-deferred savings plans, including 529 plans. And just so you know, for those of you who have opened 529 plans for your children before you knew the extent of their disability, note that 529 plans are not generally an asset of your child for benefits purposes. There are now also ABLE accounts, which are specific disability savings account that I'll cover a little bit more in a few slides. And just know that your child can have a burial account that is an exempt asset. As you're doing your long-term planning, one of the things you might want to think about is, what do you want happen to your child after they are gone? Do you want them to be with you? That is something to think about as you're doing part of this planning. But more importantly, there are a variety of government resources that may be out there to support your child. I'm going to cover briefly the four main disability benefits that are used by our children that often get mixed up because they have very similar sounding names. There are two monetary benefits: supplemental security income, often referred to as SSI, and Social Security Disability Insurance, SSDI, that can provide direct monetary benefits for adults with autism. And then there are medical benefits, including Medicaid and Medicare. The difference is, on a structural level, SSI and Medicaid are based on financial need. You have to be very, very, very poor in general to receive those benefits, Medicaid and Medicare, Medicaid and SSI. In some circumstances, your children may also be eligible for SSDI and Medicare at some point in their lives. I'm going to describe each of these benefits briefly for folks who are unfamiliar with how they work. What's important to understand for all of these disability benefits, generally, you need to meet the government's definition of disabled, which is different. All of you have a child with a disability. But to meet the federal definition of disability, you have to meet Social Security's definition. For children to be quote unquote disabled, you have to have a physical or mental condition that results in marked and severe functional limitations. For an adult, the day your child turns 18, even if they may have been receiving SSI and Medicaid, they have to be reevaluated. Because at the age of 18, you're only quote unquote disabled if you have a physical or mental condition that prevents you from engaging in substantial gainful activity. Substantial gainful activity is government speak for working, and it's a bar. So you are only, substantial gainful activity means in 2026 that you're incapable of working and earning more than $1,690 a month. When you apply for SSI for an adult, that is how they're judging your child. It is not their ADLs, it is not their IADLs, it's not their executive functioning. It's how does their disability impact their ability to work and make more than $1,690 a month in 2026. Now, unfortunately, for means-tested benefits, your child, if your child is under age of 18, because you are financially responsible for them, as a parent, your assets and income count against your child for the means-tested benefits. And that's why for many, many families, their children are not eligible for SSI or often Medicaid, except in certain circumstances. Now, once your child turns 18, parent assets and income no longer count against them. Now, SSI is a monetary supplement. In 2026, it provides up to $994 a month. I apologize for that. $994 a month to help your child pay for shelter. And but in order to get that, they have to be financially needy. That means that they have to have, at the end of every month for SSI, less than $2,000. And they have to have limited income. The reason why SSI is so important is that in most states, as an adult, if you're receiving at least $1 of SSI, you get access to Medicaid. Medicaid is a health insurance program for low-income adults as well as for what's called the aged, blind, and disabled. You want your child, if you need supports, to be on the traditional Medicaid for the aged, blind, and disabled. Because Medicaid does two things. It provides a base level of health insurance, but it's also the funding stream for Medicaid waiver supports for adults. If you need a day program, employment supports, and some kind of residential supports for an adult with disabilities, they need to be on Medicaid. Now, there are also several non-means tested benefits that at some point your child may be eligible for. The first is Social Security Disability Insurance, SSDI. Everyone gets them mixed up. SSDI is the ability to get your Social Security, the stuff you've used your FICA taxes to buy into, to get your Social Security early. And while many of you are on this call, they say, my child will never work, how can they get SSDI? There's a special rule in Social Security that if you have an individual who was quote unquote disabled from before the age of 22 and continually disabled until a parent takes their own Social Security benefit due to death, disability, or hitting retirement age, the disabled adult child, is eligible for an ancillary benefit through Social Security, similar to the spousal benefit, that allows that child to create an SSDI benefit, to get an SSDI benefit off of the parent's work record. This is important because in many instances, the SSDI benefit for the disabled adult child is higher than SSI. In addition, SSDI is important for many of our kids because when it's for individuals who are on SSDI for 24 months, they get access to Medicare as a health insurance program. Medicare is what seniors get when they hit 65. But folks who became disabled, who are able-bodied workers who became disabled and are on SSDI, they get a Medicare for 24 months. But that's also true for the SSDI payments that get paid off of a parent's work record. If your child is on traditional Medicaid for the aged, blind, and disabled, they can be on both Medicaid and Medicare. For health insurance, Medicare would be primary and Medicaid would be secondary. But they still will need Medicaid to get access to Medicaid waiver supports. Other types of monetary supports that may be available depending on your state include state supplements. Some states will provide an ancillary payment on top of SSI. There may be energy relief to help folks who are more independent pay for their utilities. There is SNAP, which is the new name for food stamps. And there are Section 8 housing vouchers that can sometimes help offset the cost of the rent for adults with disabilities. That was a brief overview, but it is important to understand there are government resources out there. You need to understand how to access them for your child. In coordinating these resources, so on the one hand, I did say, well, you should save up a lot of money because there's a lot of stuff the state doesn't pay for. And then on the other hand, you need your child to be low income so they can access all these means-tested benefits. There's a way to coordinate that, and it's through something called a special needs trust. It's a legal document. You need an attorney to create one for you in your state. This is not a do-it-yourselfer. Do not use a free online service that creates wills to do your special needs trust. These special needs trusts were authorized back in 1994 and allowed you to put aside money in a bucket to supplement what the government was providing the basic needs of food and shelter. And if set up correctly with the right magic language in your state, allows you to leave money on for the benefit of your child that doesn't count as their money for SSI and Medicaid purposes. Remember, to get SSI, you have to have less than $2,000 in the bank as a single individual. Medicaid is usually $2,000. That's the limit in most states, but some states have different limits, and you should confirm that in your state. Now, when you set up a special needs trust, you assign a trustee, which is the person who you trust, to have full discretion on how to invest the money and how to spend the money on behalf of your child with autism. And if done correctly, it doesn't count as a resource for that individual. Now, there are two general flavors of special needs trust. The one you want to set up as part of your estate plan is a third-party special needs trust, a trust funded with money that was never the disabled person's money to begin with. If it's set up that way, and you, in your beneficiary designations, in your life insurance designations, in your IRA designations, in your will, have the money go directly to the third-party trust. If there's any money left over in that bucket, when your child passes on, you get to choose who gets the leftover money. One of your other kids, a nonprofit, a charity, whoever you choose to. On the other hand, if your child is accidentally left money directly to them, grandma forgot to change her will, or there's a medical settlement where if there was unfortunately a medical malpractice suit and they have to pay the money directly to your child, you can also create a self-settled special needs trust, sometimes known as a first-party trust or a Medicaid payback trust or a D4H trust after the tax code. And the only difference is that Medicaid will allow you to take money that was given to your child and put it aside and not have the 5-year Medicaid look back, and allow your child to keep their Medicaid services and supports, except if there's any money left in that self-settled special needs trust that your child's passing. Medicaid has a lien against that money and can ask to be paid back for all the money they've spent on your kid through Medicaid waivers throughout their lives. That's why most families want to set up a third-party special needs trust and do it that way. But just know, if there's a mistake, it can be fixed. It's just not ideal. Now, in conjunction with special needs trusts, there is a newfangled type of account called an ABLE account, which is essentially a lower cost, because you don't just have an attorney set it up, somewhat lower utility with some special features, style of first-party special needs trust. An ABLE account can be funded with the beneficiary's own money. However, you can only throw in $20,000 a year, that's the number for 2026, into an ABLE account, generally, from all sources. Many people on this call, I'm assuming most of them, are worth more than $20,000 when you include retirement accounts and perhaps the value of your home that you might want to leave for the benefit of your child. So an ABLE account is not going to be a replacement for the vast majority of families for creating a special needs trust as part of your estate plan. But it's a great tool if there's excess money. If your child's getting SSI or SSDI and you can't spend their money fast enough to get them below the $2,000 asset limit for SSI or the Medicaid asset limit in your state, you're legally allowed to move money from your child's name into an ABLE account without running afoul of the Medicaid and SSI transfer rules. And that's why able accounts can be a great tool. I've got a slide. I'm not going to go into it in great detail, just showing the differences between a third-party trust, a self-settled special needs trust, and able accounts in terms of things like when does the quote unquote disability need to start? Do you have to hire an attorney to create one? Who should be funding the vehicle? What the money can be used for? Able accounts are restricted to qualified disability expenses that can include shelter. How much money you can throw into one of these vehicles in a given tax year, how much can be in a trust or an able account, how the money can be invested, who controls the distributions. One really neat thing about an able account for individuals with autism who are higher functioning, they can be in charge of their own money without having to go through the trustee as a gatekeeper. How distributions are taxed, as well as who gets any leftover money. Now, these are complicated things. I recommend folks attend a workshop or two. Sometimes it takes a while for this to sink in on on special needs trusts, as well as able accounts, to understand the differences and how it might impact you in your family's particular situation. Generally, in terms of managing financial resources, who should be the trustee, who should be the conservator, know that often families will default to a family member, but managing these financial resources, it's a little tricky and it can be time consuming. And if you think about when you pass away, how old your other kids might be, if you're putting them in charge, they may be halfway across the country. They may have difficulties in their own lives. You may want to consider working with a professional trustee. There are both for-profit and non-profit trust companies that can help manage special needs trusts. And you also may want to work with there are a number of us who are special needs financial planners to help advise the individuals who are managing the trusts with what the rules are and how things work. Finally, in terms of effectively communicating your wishes for your child, every family should have a will. When I've done these workshops live, and I ask people who have a child with autism or special needs, how many families have wills? How many families, don't have wills? I find about 25% of the audience raises their hands. Because usually the first thing an attorney will ask when you're creating your estate plan and your will is who should be the guardian of the child? And that stops us as families cold because we're thinking, gosh, our kids are tough. Who would be able to be the guardian? I think the thing to keep in mind in creating your will and addressing guardianship is that do it and you can always change your mind. You can always change your mind. When we set up our will for our son, which was 20 years ago when my son was 8, my in-laws were in their 60s. And they seemed like the perfect people to be the trustee of my son's special needs trust. Well, here it is 20 years later, we're redoing our estate plan and our special needs trust because my in-laws are now 89 and 91. They're no longer the right people. We're looking at people at maybe not even our generation, but a generation of my son to be the long-term folks. Do a will, review it every 5 to 10 years to make sure that the people you've put in charge and how you're splitting up the money is the right way. In addition, when you do your will and estate plan, consider how the money flows. Remember, not while a will generally decides where your stuff goes when you're gone, there are certain things that pass outside of your will. Anything that has a beneficiary designation, like an IRA or a 401k or a life insurance policy, goes to whoever is in that document, not what your will says. So you need to coordinate your estate plan as well as your other financial documents to make sure money flows the right way. Now, you should know not all estate attorneys do special needs planning and set up special needs trusts in a regular basis. You've worked with specialists before. You know you don't want a doctor who only works with adults with autism once or twice a year. You want an expert. And so in setting up your legal documents, you will want someone who does special needs trusts on a regular basis. You should know if there's not one that you know of in your area or your team does not work with one. There are two national associations of attorneys who work in this area. One is the Academy of Special Needs Planners, available at specialneedsanswers.com, and the other is the Special Needs Alliance that can be found at specialneedsalliance.org. If you go to those websites, you will probably be able to find someone in your state who can help you create an estate plan appropriate for your family. It costs some money, but it's well worth it to make sure your child's protected. I would say the only thing I do recommend in creating your estate plan is typically there's two ways of creating a special needs trust. One is as a separate document, and the other is sometimes the special needs trust is built into your will. While it's more expensive, my recommendation is often to have a separate trust document just for the special needs trust. It makes it easier for Social Security and your state Medicaid agency, which has the right to review your special needs trust to make sure it will work. It's much easier if all they're looking at is the trust and not trying to parse the trust from the other items that are in your will. Finally, as we go back to the beginning, and I'm pretty close to the hour, so I think I've hit this well. There is the letter of intent. This is a non-legal document. I have a version that I use with my clients. There are versions that are out there on the internet. It's essentially a basic blueprint for your child to download information. So my son is semi-verbal and can communicate some of his needs. My wife, who is his primary caretaker, she knows my son very, very well. She knows 99% of what it's possible to know about my child. I'm a decent dad. I'm at like 85%. My sister-in-law, who'd be a future guardian, loves my son. She's at 10%. If she had to take over, she needs a book to understand all the wacky things that we've put together for our kid. What are family values? What are the emergency instructions? All the medical information, the doctors to go to, the doctors to definitely not go back to. What medications they're on, what medications worked, what didn't work, what types of therapies work, what you want for living arrangements, where all the paperwork is. If you're like my family, we've got a folder with financial information. We've got a folder with legal education. We've got a whole closet filled with IEP information. You need to be able to direct them where all this stuff is. And a letter of intent is a great way to direct them. Contact information. Who's their special ed teacher? Who is their case manager for Medicaid? And then update on a regular basis. Many of these blueprints for letters of intent can be electronic. I think it's great for entering information. I also recommend if you're creating a letter of intent, make sure there's a physical version. sitting on a shelf that someone can easily find. Because if some of this stuff is only electronic, it might not ever be found. And if you've had a parent that's passed away, getting access to their computer to get all the electronic information can be maddening. So make sure, in addition to having this electronically, perhaps have a physical version that's available for families. So that is this workshop. I hope you found it helpful. I'm going to, Wendy, do you want me to unshare the screen at this stage? How do you want to work
Sure, yeah,
questions that
you
folks
can.
have had?
Well, why don't you leave that up for a few minutes, Michael, in case somebody wants to grab your email address and your website address. Thank you so much. That was packed with info.
Well, it's
Really.
hard. We often can't get folks we have busy lives. I want to make sure we packed as much in as possible to get folks the
Yeah.
right information.
Yeah. And Christine posted a poll while you were talking, and there's a lot of interest in all of the other aspects of life planning, like all of them, a lot of interest. So I hope we'll be seeing some more of you very soon. But we do have some questions for you if you can take a few more minutes and hang out with us.
I'm happy to hang out. I do these workshops for a lot of as webinars for local organizations, and I'll stay on as long as folks have questions, as long as you're willing to have me.
Okay. All right, let's dive into a few questions. And we're going to start with, is a transfer from a first party SNT to an ABLE account a taxable event?
Maybe. So able accounts are only allowed to accept cash. You cannot move. It's not like a regular investment account. It's more like a 529 if you ever use those for your neurotypical kids. And able accounts will only accept cash contributions. If you need to liquidate something in a first party special needs trust, and there is a capital gain, then that would be a taxable event. But as a first party special needs trust, that tax will be paid, will be assessed at the disabled individual's tax bracket, which is usually fairly low. That
Okay.
IRS income will not be income for Medicaid or SSI purposes because it's within the first party special needs trust.
Okay. Give me one sec because I saw another related question to that and I want to find it so we're not bouncing on topics.
Now, just so you know, one reason why some families will move money from a first party special needs trust to an ABLE account is that ABLE accounts can be controlled by the disabled individual, and that allows some autonomy for that individual. And B, in some states, about 18 right now, ABLE accounts are not subject to Medicaid liens. That is a
Okay.
state by state decision. And so moving it from first party special needs trust where there's a Medicaid lien to an ABLE account where there's not a Medicaid lien can have certain advantages for some families.
Okay. So another question about the ABLE account was, given the Medicaid look back for the ABLE account and the $100,000 max before your SSI is paused, is it most ideal to never get over the 100K mark so that your child can get the monthly SSI? Or if you have the capability to fund it beyond that, but stay under the 500,000 balance in Washington state, so Medicaid wouldn't be paused. Is there a limit to how much you recommend funding an ABLE account, Michael?
As always, it depends. So just so you know, using a disabled individual's own money to place it in an ABLE account, that transfer is not subject to Medicaid or SSI lookbacks. That's
Okay.
built into ABLE accounts. Number two, for ABLE accounts, it is never a resource for Medicaid purposes.
Okay.
However, any dollar, once your ABLE account reaches $100,000, any amount above that $100,000 is a countable resource for SSI. So if you had $101,000 in an ABLE account, only $1,000 of it would be countable as a resource for SSI. If their other resources were did not push them over the $2,000 limit, they'd still be eligible for SSI.
Oh, that's interesting. Okay.
I think the key is for if an individual is still on SSI, you probably want to keep the ABLE account below $100,000.
Okay.
At some point, your child may be on SSDI, which is a different monetary benefit that doesn't have an asset limit. Finally, most ABLE accounts have a theoretical dollar limit. It sounds like in Washington, it's $500,000 built into the tax code for each state. An ABLE account in a particular state has a certain theoretical maximum limit. Once the ABLE account reaches that limit, it's usually in the $300,000 to $500,000 range. You can still keep the ABLE account. It's still an exempt asset for Medicaid. You just can't put any more money into it.
Okay.
However, overfunding an ABLE account like that does have some challenges because when the individual with disabilities passes away and that money then goes to an heir, the distribution of that leftover money is subject to income taxes. Sorry, the gain on that leftover money is subject to income taxes. And because it's be considered a non-qualified education, just non-qualified disability expense, the gain on that account would be also subject to a 10% federal penalty tax. So there, again, depending on your family situation, you may not want to necessarily overfund the ABLE account. It's always a balance.
Okay. Gotcha. This question goes back to early in your presentation. What is the proper way to apply for the APD waiting list?
So this sounds like someone from Florida. So each state has a different agency that provides Medicaid supports for adults with disabilities. In Florida, it's APD. So I'm assuming this
Okay.
person is in Florida. Um, there is no wrong way to apply for the waiting list. In any state that you are in, you should first always register your child. Again, assuming they meet the support criteria for Medicaid waivers in your state. For example, in my home state of Connecticut, we have one waiver for individuals with IQs under 70, regardless of their comorbidity like autism or Down syndrome, and a separate Medicaid waiver for individuals with autism with IQs over 70. There's no wrong way. You should always put your child, register them with the state agency as early as possible,
Mm-hmm.
even if you don't think they will need supports.
Okay.
And but many states do have wait lists even for day supports, especially outside of the Northeast and the Northwest. And so there's no harm in being on the wait list. Where the worst that happens is if you get off and your kid doesn't need it, you don't accept the waiver.
Yeah. And you celebrate that your kid doesn't need it, right?
Exactly.
There you
Exactly.
go. All right. Next question. If the child is able to live in the parent's home after passing, can the home be put in the trust name for the child?
Yes. So one of the reasons why, while your child can own the home themselves and it is a Medicaid asset during their lifetime, uh, once the child would pass away, if the child owns the home and they received Medicaid waiver supports, the um, the asset would be subject to Medicaid lien. We often see families leaving the house to a third party special needs trust
Mm-hmm.
and having the child live there. The question will be, will that be the right environment for them? And will the Medicaid waivers they receive be able to support them in that house? So I had mentioned that up here in the Northeast, a 1-on-3 staffed group home costs about the state about $150,000 a year in Medicaid waiver supports. that staffing is based on one staff member for 3 adults. Even if that's the level, and that's how they're funding it. If your kid doesn't need one-on-one supports, the state may not pay for staffing to support your child by themselves in the family home.
Mm-hmm.
And so whether that strategy is going to work or not is dependent on the abilities of your child, what supports they need, and what their residential budget will look like once the parents are no longer in the picture. That's something to discuss with caseworkers to have a better understanding of what will happen in your state.
Gotcha. So would it be smarter to just put, because I'm actually going to be doing this, put my house into a trust, that it will be like a non-revocable trust after I pass away. The house will be part of the assets. Those assets will be used by the trustees for the benefit of my daughter at my direction. So does that sound like a good plan to do something like that rather than
It
getting
is. I mean,
like, you don't
there's
want your
nothing,
child to own the house, I imagine.
you don't want the child to own the house.
Yeah,
They can, you don't want it. I think
right.
the issue is it's okay to leave the house to the trust.
Yeah.
Don't restrict the trustee that if it's better for your child because your house is a colonial
Mm-hmm.
and they're now 70 and need a ranch, you want to
Mm-hmm.
make sure you're not restricting the trustee from selling the home.
Right.
The home is an asset.
Mm-hmm.
Whether it's better to use it for their actual brick and mortar residence or use the proceeds from that to support them someplace else is going to be the trustee's decision.
Yeah,
I would only
exactly.
say if you're leaving a trust to the house, make sure there are enough liquid resources in that trust to support the
Mm-hmm.
house. Remember, if the trust owns the house, they got to pay property taxes, they have to pay homeowners insurance. If there's staff there, they have to have liability insurance. You got to pay utilities. You got to replace, you got to do upkeep. Our kids are tough on houses. You still have to replace a bathroom
What do you
every X
mean?
number of
What do you mean,
years.
Michael? I have no idea what you mean.
I'm on the board of a local agency in my hometown, and you know, we have a lot of kids who are gentle and a lot of kids who are behavioral. And sometimes they will put holes in the wall.
Mm-hmm.
Sometimes they will, scratch up floors. Sometimes they will put things in toilets and flush them because that's what they like to do. Um,
I
you may
can't
want to
imagine
build it.
that.
Can't imagine that. You may want to build in extra money to be able to pay for that upkeep to make the house as nice as you want it for your kids from that
Exactly.
standpoint.
Yes. All right, next question. How do we know what kind of trust account to have that is tax exempt? What other accounts can we have set up that are tax exempt that won't discontinue already received government benefits?
So I'm going to try to interpret this the best way. Other than ABLE accounts, there's a difference between a trust and an account. Think of a trust as a company that you're hiring to care for your child. And the trust account, where the money for the trust is going, is an account the trust owns. There are no tax exempt trust accounts. Theoretically, if there was a Roth IRA that was left to a trust, that would be a tax exempt account. But trusts themselves have very complicated tax aspects, more than we can go in today.
Mm-hmm.
But know that for most families, the majority of families probably do not want to fund their third party special needs trusts until they die, or unless grandma's going to leave a lot of money to it, because of the complicated nature of running a trust.
Right.
And if you're using a trust as an accumulation vehicle, trusts can be fairly tax inefficient. Once they start spending the money on the kid, they become much more tax efficient.
Okay. And Megan is asking, can a parent be in charge of the special needs trust?
When the parent is alive, absolutely.
Hmm.
So if your child has a first party special needs trust funded from a medical malpractice suit or an accidental inheritance too high to shove into an ABLE account, yes. Or even a first party special needs trust to hold um, uh, excess income like a pension or child support, certainly mom or dad can be the trustee of that trust. But once you die, someone
Hmm.
else has to be the trustee
Right.
because you're not
And
here.
and that has to be in your will
It
so
has to
that
be
it
in the trust
passes.
doc. So
Or
so
the okay, yeah.
however the trust is created, whether it's
Yeah.
created as a separate document or in your will, that document specifies who the trustee is. And it'll also specify, well, if that person's not around, here's a successor trustee,
Yep.
and here's the person after that. And then usually when you run out of people, you give the option for the last trustee standing to name their own successor.
Okay. Excellent. All right. My son is only 6 right now, so we are not 100% sure where he will be in 12 years. At what age would you recommend setting up a third party SNT?
Now, for all families, I recommend setting up an estate plan with an unfunded special needs trust. Even if you have a child with autism who's 6, and granted, we don't know what neurotypical 6-year-olds will be when they grow up, let alone one with autism.
Hmm.
But even if they progress to the point where they don't need Medicaid waiver supports, God bless, many adults with autism can be socially naive. And it may be helpful if the individual with disabilities is no longer quote unquote disabled, as I described earlier, they may still need
Yeah.
help with money. And the special needs trust can default to a plain old trust to help that individual not get taken advantage of. I don't know that any 18-year-old should be left a lot of money without having a trust
Hmm.
because people in their 20s make stupid mistakes. Bad first marriages, investing in swampland in Florida, just getting taken advantage of, going bankrupt. Having money in a trust for a young person, autism or no, can often be a very good idea to help protect them.
Yeah. All right. Let's answer this question because it's really important. Will a child having a bank account hinder the Medicaid waiver? The money was gifted to him by family members. Shoot.
It depends. So typically, if your child is under the age of 18, um, for states that provide Medicaid waiver supports, often they are waiving the asset and income limit for those children and for the parents. So under 18, a custodial account where grandma has left, $3,000 or $4,000 for the kid, or 10 shares of Disney, that money will generally, in most states, not impact Medicaid waiver supports under the age of 18. However, once the child turns 18 and that money is turned over to them, in most states, custodial accounts are turned over somewhere between the ages of 18 and 21, depending on the state. Once that money is turned over to them, that money will count as a resource and will impact their Medicaid waiver supports.
Hmm. Okay.
The ways around that include spending the money on their behalf, moving it uh, to an ABLE account. Sometimes that has to be over time if there's more than, say, $20,000. Or if it's too much money, sometimes a first party special needs trust will have to be created to shield the resource. But how you shield the resource depends on how much money there is.
Okay. After 18, does parent income count for SSI typically? My son is 21 and we have already tried and been denied for basically everything. But in the event of our passing, I would like to know how to prepare for someone else to help him try again.
So post 18, parent assets and income no longer count against your child. If your child has been denied SSI, Medicaid, and Medicaid waiver supports, well, let's start with SSI and Medicaid. If they've been denied SSI and Medicaid, the only reason for that would be either A, they had too much money in their name, or B, they did not meet the government's definition of disability. If it was because they had too much money, that can be taken care of. If it was because they weren't deemed to be disabled enough to be disabled, then that is a different issue. And there would have to be a change in their medical condition in order for them to be qualified as disabled. Regardless, if you feel your child is one of those in-betweeners, my dad would call them too light for heavy work and too heavy for light work, too high functioning to not be considered disabled, but not high functioning enough to manage on their own, then having a special needs trust operating as a plain old trust will help protect them from themselves while still being able to leave them money to have someone help them to manage their financial affairs.
Okay. Dory says, our son has no siblings, no extended family, and we are older parents. What do people do when they don't have anyone close to them who would care for their adult child after they're gone?
It's a great question, and I get this a lot. We only have one child. We're lucky enough that my niece and nephew live close and will be able to provide some oversight. For the financial side, there are a number of both for-profit and nonprofit trust companies that have experience with managing special needs trusts, that understand the complexities of allowing the individual to qualify for government benefits while also protecting them from, as a good lawyer friend of mine would say, creditors, predators, and divorce. That will help for the financial side and help them manage that area. If they need a legal guardian, that's going to be a different challenge. And that's something to discuss with a local agency that may be providing supports in your local area. I have seen some professional trustees who hire care coordinators. And again, especially for those who have more medical needs that are more complex, the trustees can be directed to hire additional supports to help in the community, depending on the financial resources available.
Okay.
I wish there was a better answer, but typically a professional trustee would be more appropriate in your situation.
Okay. Sherry says there is information circling around various organizations stating that the family assets do not impact the child's ability to qualify for SSI. Can you clarify this information?
So it depends on your child's age. When the child is technically, children who meet the government's definition of disability are eligible for SSI and Medicaid. However, when they're under 18, parent assets and income count against them. Once the child turns 18, for any benefit but SNAP, parent assets and income no longer count against them for Medicaid and SSI purposes. SNAP is the one exception. For SNAP purposes only, parent assets and income generally count against the child till age 22. Why? Well, if it didn't, every college student in America would be on food stamps.
Right.
But for SSI purposes, post 18, parent assets and income do not count against them, even if the parent chooses to become the legal guardian. Becoming the legal guardian of an adult does not attach any financial responsibilities.
Okay. All right. Aaron says, so I am understanding that it is best to fund the third party T when I die using a Roth IRA or traditional IRA. My son is 16 and I want to set something up now for his sister to be the trustee for him later.
So I wouldn't say it's quote unquote best to fund the special needs trust with an IRA or Roth IRA. It's a question of what are the family resources. Your resources probably include a house, may include a house, an account, savings and investment accounts in your name, Roth IRAs, regular IRAs, life insurance. All of those are family resources. For a particular family, there may be, some families take the easy route and just say, I have two kids, 50-50 of each asset.
Hmm.
Other families get a little bit more complicated and try to slice and dice which assets would go where. And there may be certain tax reasons, depending on the size of your wealth, uh, that you may choose to have all the IRAs go one way and all the non-IRAs go another way. But that could be complicated and would have to be reviewed every year to make sure things get equalized in the way you want. I would say, I don't always say don't fund the third party special needs trust. Um, there are sometimes reasons to do it. If you're worth more than $30 million and need to do estate planning, sometimes it could be helpful to fund a third party special needs trust. Most folks don't have that kind of wealth, but there can be reasons for a particular situation to fund a third party special needs trust now, but this is something to really discuss thoroughly with your legal, financial, and tax advisors to understand the consequences.
Hmm.
That's why in
Okay.
this kind of talk, we're talking with folks from 50 different states probably and very different financial situations, different family situations. There may be blended families. These are general rules. Every family should discuss with their individual advisors what makes sense for them based on
Yeah.
their situation.
Yeah. Actually have a question. Who can help me know if I set up my irrevocable supplemental care trust correctly? I ask because the attorney who helped me, I'm not confident in. And you did have a slide in your presentation of two
I'll
different
go.
websites that people could go to.
And I'll go back to that. So there
Thank
are
you.
two groups of attorneys: the Academy of Special Needs Planners and the Special Needs Alliance, that are attorneys who have expertise. There are attorneys in every state, just about. I think Alaska, there's only one in one of the organizations because I was looking up the other day. But there are experts in your state that can help with this. There are quality attorneys who do not belong to either organization. So
Hmm.
this is not to say that if someone doesn't belong to one of these, they're not a good special needs estate planner. But if you're not sure and you want a second opinion and don't know who to reach out to, reaching out to one of these organizations will help. In fact, the Academy of Special Needs Planners also lets in financial advisors. They're having their annual meeting at the end of the month in Miami. And I'll be there to interact with the attorneys to help, keep up my education about things that change.
Okay. Awesome. Um, Irrevocable or revocable? I'm going to say that three times really fast. Doesn't matter. Can you explain the difference between the two types of trusts?
Absolutely. Revocable, REV, means that you can change the special needs trust. You can change that trust. Irrevocable means you can't change the special needs trust. Now, once you die, whether your trust was revocable or irrevocable, it becomes irrevocable and can't be changed. There are many attorneys will prefer to set up irrevocable special needs trusts, but there are some circumstances. And by the way, all first party special needs trusts are irrevocable and can't be changed. There are some circumstances where a third party special needs trust can be revocable. Uh, there are sometimes certain tax reasons for this that are more complicated than I can go into kind of this forum. But generally, once the parents die, all the special needs trusts become irrevocable.
Okay.
I hope that helps.
Yep. So you have control with a revocable trust. You have control until you die. And then after that, your instructions have to be followed and nothing can be changed.
Correct. So if it's
Okay.
revocable, you can make changes. But
Mm-hmm.
even if it's irrevocable, often you can make changes as long as it's not funded.
Okay.
That's another reason it's often not to fund the third party trust because you can make changes before you put the first $100 in.
Okay. Gotcha. All right. I'm going to ask you one more because it's almost 8:30 and I'm sorry to everyone that, we just can't get to all of these questions. I have a whole slew of them, but let's call it a night with this one from Mandy. Is having both an able and a special needs trust a good idea, or is one or the other sufficient?
So I will say that having only an ABLE account is not sufficient. An ABLE account cannot replace a special needs trust as part of your estate planning.
Mm-hmm.
You cannot name an ABLE account a beneficiary of your will or an IRA or a 401k or life insurance policy. However, an ABLE account can be a good companion tool to a special needs trust. ABLE accounts have lots of really good uses like shielding resources and being able to give the individual with disabilities control over more money than they would ordinarily be allowed to, given SSI and Medicaid asset limits.
Okay.
It is an ancillary tool that can be used during the parent's lifetime, but it's not a replacement for a proper third party special needs trust.
Okay. Gotcha.
But you can have both. Many families have both.
Yeah, I mean, it sounds to me like it would be a good idea to have both. I like the freedom for the person, you know, for your child, your adult child, to have access to the able account funds, and have some freedom there, some financial freedom there. But I also like the structure of the trusts and the
Well,
trustees, but it is, this is why I wanted to bring you on, Michael, because like there's so much. And we had some people in chat saying my head is spinning. That's why we're doing this because it is just a huge issue that we all have got to deal with at some point, and otherwise we're not looking out for our kids, right? We have to do this, and there is a lot to understand about it, and you need somebody local that you can work with who can hold your hand. Literally, my special needs attorney is holding my hand and walking me through every single step, and it's not easy. There's a lot of work involved. There's a lot of time spent planning for this, and it's really important stuff. But once you get, I'm the kind of person who gets like really overwhelmed by things, and then I just ignore them. And
you're
and
not
I've
alone.
done that for years with this life planning stuff, I just could not wrap my head around it. It was too big of a thing for me. And I kept walking away. And then I decided, okay, that's it. I'm doing this. I have to do this now. And now that I've started it, it's not as scary as you think it is, everybody. It's really not. You just need to have the right people advising you and walking you through it. And you're going to be okay. And once it's done, you're going to have a sense of relief knowing that you've now answered the question of what is going to happen to my kid when I'm gone. So don't be
And I,
afraid. Tonight was your first step. We're on this journey together. Michael, thank you so much for your time and your knowledge. We
my
really
pleasure.
appreciate you. It's
And
so
I would
good
say
to see you.
I would say one last thing. You know, I threw a lot of information at you tonight, partially because there's so much that covers. Not all of these two things may apply to all families. When you
Hmm.
work with your local professionals, or there are folks who work, in multiple states as well, and that's something that I do. But when you do that, they will help narrow down the issues for you and present the choices in smaller chunks that will make a lot more sense for you
Yeah.
and a lot more sense to you.
Yes.
It's just hard in a forum like this. I kind of have to present a lot of stuff because we have to cover a lot of things to make sure at least you have the ideas in your head. Not
Hmm.
all of them are going to apply to you.
Yeah. That's true. There were things that I thought I was going to do that I ended up not doing. So I love that you threw it all out there because just like all of our kids, everybody is different. Everybody has different needs. And knowing all of the options is great because now you can start to narrow them down to your specific situation. So we appreciate that very much. For everybody who joined us tonight, thank you. We're glad you were here with us. And you will receive, if you join through Zoom, you're going to receive a follow-up email from Christine when we post this video on our website if you want to rewatch it. And also, Michael was kind enough to provide us with his slides from his PowerPoint. So we'll be emailing that to you as well. Our next webinar is in a couple of weeks. It's going to be on April 21st. We're going to be speaking with Martha Carlin, and it's all about the gut-brain connection and what every parent needs to know about the microbiome. It's going to be really interesting and sciencey. So if you didn't have enough tonight, join us on the 21st for some more. We'll go from mathy to sciencey. But thank you so much, everybody, again for joining us. And Michael, it was a pleasure, and I hope you will come back very soon because those poll numbers, we need you.
Whenever makes sense, just give me a shout and I'll make time.
All right. Thank you so much for being with us. Everybody have a good night, and we'll see you soon. Good night.